An unwritten rule. The Guernsey Court of Appeal on informal trust declarations and the presumption of equality. A handwritten note, a single sentence long, with no witness, no signature block, and no mention of how property should be divided. Can such a document constitute a valid declaration of trust? The Guernsey Court of Appeal has confirmed that it can. In Ashdown versus Fraser, the Court of Appeal dismissed an appeal against a royal court decision upholding the validity of a handwritten document by which a settlor declared the shares in a family company to be held for two trusts, without specifying the proportions in which each trust was to benefit. The decision offers useful clarification on the doctrine of certainty of subject matter, as well as guidance on how informal trust instruments ought to be construed, and how the venerable equitable maxim that equality is equity continues to do meaningful work in modern trust litigation. Background. Victor Ashdown, the settlor, was a successful businessman who held the entire issued share capital of Sylvan Holdings Limited, comprising 100 shares. He had two children, Mark and Jane. During his lifetime, he established a number of professionally drafted family trusts, including the Victor Ashdown Trust for Mark, established in 1989, and the Victor Ashdown Guernsey Settlement for Jane, established in March 1994. On 9th of August 1994, the settlor wrote the following by hand. To whom it may concern. The shares in Sylvan Holdings Limited are now to be held in Mark's and Jane's Trust. The 1994 document. A contemporaneous trustees' meeting minute recorded the settlement of shares into trust on the same date, though the minute did not itself identify which trust or trusts were intended, nor any proportionate division between them. The settlor never transferred legal title to the shares. In 2015, he executed a stock transfer form, transferring them into Mark's name. The 1994 document was not discovered until April 2022, shortly before the settlor's death. What followed was a dispute between Mark, executor and personal beneficiary of Mark's trust, and Jane, supported by the trustees of Jane's trust, as to the effect, if any, of the 1994 document. The dispute. Mark, the appellant, argued that the document was not a valid declaration of trust. At best, it was an aide-memoire, or statement of future intention. In the alternative, he argued that it was void for uncertainty of subject matter. The document said nothing about how the shares were to be divided between the two trusts, and that silence was fatal. Jane, the first respondent, resisted, contending that the 1994 document constituted a valid declaration of trust over all 100 Sylvan shares in favour of both trusts in equal proportions. At first instance, in the royal court, the deputy bailiff at first instance upheld the declaration, finding that a reasonable person would infer equal division. The royal court granted leave to appeal on 3 grounds. The methodology used, the reasonable person formulation, certainty of subject matter, and the construction of the 1994 document as a present declaration for 2 trusts in equal shares. The Court of Appeal's decision. The Court of Appeal dismissed the appeal on all 3 grounds. A present declaration of trust, despite informality. The court rejected the argument that the 1994 document was merely a note to self, or a statement of possible future intention. The critical words, "are now to be held," were found to be strongly indicative of present intention, not aspiration. Relying on the Privy Council's decision in Choithram T. International SA versus Pagarini, the court emphasised that informality does not negate legal effect, where the intention to declare a trust is sufficiently clear. Equity will not strive officiously to defeat a gift. The contemporaneous trustees' minute further reinforced the conclusion that the settlor intended a present settlement. The court also dealt squarely with the argument that the settlor's subsequent conduct, including his failure to act on the document and his later transfer of the shares to Mark in 2015, undermined the declaration. It held that this was of questionable relevance and certainly not decisive. A declaration of trust by the legal owner is effective without any transfer of title. The trust arises by virtue of the declaration alone. Therefore, the settlor's subsequent conduct could not retrospectively unmake a declaration that was effective when made. The court cited the general interpretive principle, recently affirmed by the Privy Council in National Commercial Bank Jamaica Limited versus NCB Staff Association, Jamaica, that post-instrument conduct is irrelevant to interpretation. The Lehman Brothers distinction, proportions versus property. The central legal issue was whether the failure to specify proportions between the two beneficiary trusts rendered the trust void for uncertainty of subject matter. The appellant relied on re Lehman Brothers International Europe and the principle that trust property must be identified with sufficient certainty. The Court of Appeal drew a critical distinction. In Lehman Brothers, the trust failed because the trust property itself could not be identified. It was described as a portion of a larger pool without any mechanism for ascertaining which portion. Here, by contrast, the trust property was identified with perfect precision. It was all 100 Sylvan shares. The question was not which shares, but in what proportions do the two trusts share the beneficial interest? That, the court held, was a question of construction or equitable presumption, conceptually distinct from certainty of subject matter, and not one going to the validity of the trust itself. The court noted that this analysis was consistent with Hunter versus Moss, which establishes that a beneficial interest in a proportion of an identified fund of fungible assets is sufficiently certain to found a trust. Equality is equity. Having found the trust property certain, the court held that equal division followed on two alternative bases. First, on ordinary principles of construction. The settlor had two children, had established one trust for each, and wrote a single, undifferentiated sentence, placing the shares into both trusts without any indication of inequality. In the context of a family settlement, the absence of differentiation supported a construction of equal division. The court drew an apt analogy. If a testator devises property to my children A and B, no one would suggest the gift fails because the shares are not expressed. Second, and in the alternative, the maxim equality is equity operated as a recognized legal rule to supply equal shares where the instrument is silent and there is no evidence of contrary intention. The court cited Jones versus Maynard, re Gorman, and the Guernsey Authority, Waterman versus McCormack. This was not judicial speculation or impermissible gap-filling. It was the application of a long-established presumption operating as a matter of law. The court reinforced this conclusion by drawing on the contractual analogy from Royal Bank of Scotland plc v Carlisle, in which Lord Hodge observed that once a court is satisfied the parties intended to make a legally binding commitment, it is entitled and indeed required to look for ways to give effect to that promise. Similarly, having found that the settlor objectively intended to settle the shares into trust, the court should do its best to give effect to that intention, so that, in the words of Lord Tomlin in Hillas and Company Limited versus Arcos Limited, the law may not incur the reproach of being the destroyer of bargains. The reasonable person. Finally, the court addressed the appellant's challenge to the deputy bailiff's use of the phrase, "a reasonable person would infer." The court acknowledged that the expression was not the most felicitous, but held that it was no more than shorthand for the orthodox objective construction exercise described in the matter of K-Trust and Investors' Compensation Scheme Limited versus West Bromwich Building Society. The court remarked that the reasonable person is not a separate or impermissible legal test, but the very lens through which construction has always been conducted. Infelicity of expression does not amount to an error of law. Comment. This decision confirms that Guernsey courts will lean in favour of upholding trusts rather than defeating them on technical grounds, and is generally a useful affirmation of several important principles for practitioners and trustees operating in the offshore trust industry, and for those advising on Cayman Islands trust matters where similar principles apply. Failure to specify proportions between beneficiaries is not the same as failure to identify trust property, and the Court of Appeal emphasised this conceptually important distinction. This reminder provides comfort where trust instruments are silent on the apportionment of beneficial interests among multiple objects. The presumption of equality has real practical force and can save an otherwise silent instrument from failure. For settlors who make informal or incomplete provision, and for trustees who discover such documents after the event, the maxim offers a principled default. The decision also serves as a reminder that subsequent conduct, including a settlor's failure to give effect to a declaration, or even apparent inconsistent dealings with the trust property, cannot retrospectively unmake a trust that was effectively established when made. The interpretive exercise is anchored at the date of the instrument, not at any later point. While this is a decision of the Guernsey courts, and we do not advise on Guernsey law, the principles affirmed by the Court of Appeal are rooted in equitable doctrines that are shared across the common law offshore world, and are of direct relevance to trust practitioners and trustees in the Cayman Islands.